you feel it went?
It was interesting, it was difficult. Oh boy, they did not want me to talk about this. They wanted me to talk about their driving offence. I was having none of it. I was talking about what happened before that in order that I was policed and we were brought there. And I did get to give my whole case. I did get to put all my 3 points, my submissions up there. The judge was happy. I asked him, I'm going to put these points out to you and give you these submissions unless you direct me otherwise. And he said, no, you carry on.
So you feel you got a fair hearing?
Yes. The barrister was determined to twist everything I say, as of course they do, and that I was making a statement saying the Crown hasn't got this and the Crown can't do that. So I did actually attempt to object, but the judge shut me down at one point. And then I said, contrary to what counsel has just said, I have never made any statements about what the Crown does or does not have. I simply said that they have never presented any evidence whatsoever, and if the court allows that, then they're allowing force to be a higher authority in this court of law. I talked for 20 minutes, which the judge mentioned. Yes, you have talked for 20 minutes now. And then the Crown barrister summed up what I said by saying, of course, she has presented quite a few very interesting points here. But we're not going to go in. We're going to talk about the driving, and we went back to that again. So I tried to bring it back, and I tried to say to the judge, we need to look at what happened before I came to court.
The judge did give you a chance to respond after he summed up.
Yeah, and now we've adjourned for lunch. But what was interesting was before we went in. Before we went in, a man in a gown who identified himself as a court solicitor. He said he wasn't a duty solicitor because they don't have those in Crown Court apparently. So could I have a word with you? I think I've got something you might like to hear. And I thought, oh yes, alarm bells, what are you up to, matey? And we went into a little side room and he asked me what my first name was, and I said Sarah, and we proceeded to sit down and I said, so what's yours? And he said, what's my what? I said, well, what's your first name? So Kevin and I sat down and discussed, and he gave me an out. He gave me a timeline of when the documentation was originally received from the police and when I had the dates, the 28 days to respond, and the date that they said I committed the offence was wrong. It was wrong on the paperwork and I didn't commit any offence on that date. If the Crown had realised that at Magistrates' Court, they could have appealed to amend the documentation and carried through then, but they didn't. And now it's got to appeal. They can't change that, so that date that I allegedly committed the offence is set in stone. And it doesn't add up to the timeline. It's about 8 days after the alleged offence. So I've got a point of law that I could have wiped it all out. And he was absolutely determined that I was going to take this. He'd seen all my documentation, he knew what I was talking about, and he kept saying, I don't want to deal with that. He said, I'll represent you, I'm happy to represent you. I'll go in and give you this, I'll give you this. And I said to him, why are you doing this? He said, because I'm just a nice guy.
He did seem quite anxious that you would agree to go with that defence.
He kept saying, this is your point, this is your plan A, and the other stuff you've got there that I've seen, but the judge is not going to allow that. He said, that can be your plan B or plan C, but then you won't need that, because if you're going with what I've given you now, that will be the end of it. Your appeal will be upheld and you can go home. And don't you want to go home? You want to go home, you don't want to be here all day, do you? Which was curious because we were booked in at 10 and we didn't go until 12, and a lot of other cases went before us. And then he came and said something very interesting. He came back 2 or 3 times. He came back first, there's quite a few people here with me. He came back first and said to him, what do your friends think about all this? I've given you this out. I'm sure your friends will advise you that that's the best thing to do and not this other stuff. I'm happy to represent you for that, but not that other stuff. I'm going shopping, he said. And I thanked him kindly for his help and said no, I wouldn't be doing that. So he went shopping back into the court again.
As opposed to soliciting.
Stayed there. And what else was it he did? He came back again.
Yes, he did.
And said, if you want this, if you want me to do this, I'm going to do this. We'll go in now. I'll do this for you. I'll do this for nothing for you. I'll go in and represent you. We'll use this argument now and you'll win and you'll be gone home and that'll be the end of it. I'll do it for nothing now. We're going in now, he said. And so we all got up and followed him. And I said said at the door, thank you, but no thanks, I'm still going to do what I want to do. And he then said, oh, well, no, actually, there's 2 more before you. You have to go and sit down again. I just felt very interesting.
Yes, they did seem determined to keep us waiting as long as they possibly could.
But if I took his advice and I allowed him to represent me, it would have all been
over and done
we'd all
out and
gone
home.
Yeah, very kind man.
Well, thank you, sir. Okay.
Tell the press whatever you like.
Oh yes, you can tell the press whatever
Oh,
you
you
like.
can say that then.
Yes, he did say that.
Came back and said,
Once you've gone through, once you've got out, you can tell the press anything you want. There's a couple of notes that I've made during the thing trial, whatever it is. Your quasi-legalistic gobbledygook. I quite like that. I thought that was rather nice. And the judge actually did ask at one point, what is the law of the land? Which I thought was an interesting thing. And the prosecution said the owner of the vehicle is presumed to be the driver. So that'll be the DVLA then. That's about all I've got on it. I mean, you know.
Okay, does anybody else have any comments to make?
You wanted to tell him about what you came and said afterwards about the press.
I did say that. Yes, he said once you've got off with his solution, you can go and tell the press whatever you want. So,
Curious,
which
no one
suggests
had
that
ever mentioned anything.
nobody's mentioned the press, and it's very nice to be a friend. Oh, and your evidence, of course, has been selected from various law books.
Somebody's been to a law library and put a quasi-legalistic...
You've not been quoting case law, have you?
Of course, it's not quite what they do, is it?
Yeah, because they don't go to law libraries.
Okay, so we're going to go back in after lunch and see what the outcome will be. So, Sarah, having heard the deliberations of the appeal court, what's your reaction?
It was pretty much as what was expected. I was told we can't opt out of our statutory duty. It was listened to, it was discussed. It was Judge Graham Cottle, who I know of old from when I used to work alongside him. He was pretty good, actually. He was good in the sense that his hands were tied. He couldn't allow it, and I think he said something like, I can't allow this because if I ever did, it would be anarchy.
Indeed.
He did say those words, or words to that effect. I'm sure Max has got it written down, or Kate, somebody's got it written down somewhere. So we had £150 cost for the barrister for today added on, and I have been given £5 a week to pay, which is great, because previously they said I had to pay the whole lot off in 14 days to go to jail. So that was interesting. It will be appealed. I will appeal it. I've got to make this first payment in a week, so I will appeal this within a week. But I don't know how just yet. We'll get back to you on that. That's it.
Okay.
You have to say that the judge did state that you were very succinct, and you expressed yourself with commendable clarity.
Oh.
But he was sticking with the undisputed facts of the case.
Which were all about the driving
Which were all about the driving stuff and nothing about the consent at all.
But he did
which
go
is
there.
a dispute.
He did go there, didn't he? He did discuss it.
Yes, he mentioned statutory duty, which, again, I'd like to see evidence of where that comes from. Is it written in the statute? You have strong views and selective research. Now, I'm not sure that...
Yes, you've been drawing on law libraries.
Yes, it's as if she'd gone to a law library, gone through all sorts of books and written a legal argument. Well, duh!
Now, the way I've written this down, this might not be how he actually said it. I think you have it, Kate, actually. We cannot opt to abide by the law of the land.
Otherwise we descend into anarchy.
Otherwise we descend into anarchy. So we can't choose whether we follow
but I did keep
the
pointing
law of
out
the land,
to
which
I did keep pointing out to him
isn't
that wasn't what the
statutory.
case was about. The case was about being policed by consent, and they kept trying to come at it from almost the same angle, but not quite.
Interesting that they mentioned your argument. The prosecution bloke, or whatever you would call him, he called your argument. He called it a perverse argument. But then the judge decided it was a non-argument.
Yes.
He also referred to it as legal gobbledygook.
That was the
earlier on.
quasi-legalistic gobbledygook.
Yes.
Something called lioness law.
The judge didn't say that. That was
Yes, that was also a
that was the
point.
Crown.
Lioness law was brought up twice in the court.
Yeah, and not by me.
But I like this. The owner of the vehicle is presumed to be the driver. Now,
So that's a building driving a...
the owner, as far as I know, the owner,
It's not the same as the keeper.
when you sign over, when you register your car, the owner then becomes the DVLA.
registration being transfer of title
Well, we
ownership.
don't know that.
Well, we
and
don't
they
know
have
for
denied
certain.
it, but
We-
the owner is not the same as the keeper. We do know that.
We do know that the owner is not the same as the keeper.
What did,
He used those two terms interchangeably, didn't he?
Well, we cannot opt to abide by the law of the land.
Which would
that,
be...
that
Can't allow
wasn't,
that,
that
can we?
wasn't what I was saying.
Yeah.
And that was actually opinion, I think.
Obfuscation. It was.
It was that wasn't, you know, that was a judge actually expressing an opinion, I thought.
Again, yeah.
Which is that law?
They didn't tackle the main thing, which was the admittance of opinion as evidence, which was your point,
Yeah,
wasn't
that
it?
Well, I've said it a
yeah.
number of times.
Yeah.
Yes, opinion is not evidence.
That's right. And it was the
In
opinion
accordance with the rules
of the
evidence,
government,
the civil procedures rules and the criminal procedures rules, which I quoted. And I also said that if you allow this, then you will be holding force over having a higher authority here than law.
I think that actually hit home, personally. The buzz in the court, when you said that, there was a definite sort of,
oops,
what's the word? A pause of thought.
But Kevin, who offered the kind help, who said he would represent me and go in and give me this special one-out thing to do with the dates of the original notice of prosecution from the police, was absent when we got back. He wasn't there at all. We didn't see him again. And listening to what the Crown said about the case, it became apparent that the advice that Kevin had given me and that what he was going to represent me on was in fact incorrect.
spurious.
Had I gone through with that and used that as an argument, I would have proven my guilt beyond any shadow of doubt.
So somebody set him up to do that?
We don't know. We can assume, but assumption doesn't get us anywhere. We don't know what or why.
Well, we can presume.
presume.
But he was very, very, very determined that I should do it, or wait all day, and then we did get to wait quite a long time.
Never known
And
a
then he was
brief
absent.
to want to work for nothing quite so much.
And offering. No, he was
No, we
really
can-
very, very keen that I should have this and I should do this.
We can presume, though, he is an officer of the court.
Well, he said he
Yes.
was.
Well, he was wearing the gown, so.
Well, he said he was.
He said he
and
was.
he also said he was. Yeah.
Court
Yeah.
solicitor. But yeah, so
Right,
thanks,
stop
Kev,
that,
but
No
glad I
thanks.
didn't go with that then.
Yeah.
So, appeals next.
And you
Study.
appeal to?
Hmm?
And you appeal to?
Don't know, I've got to study now, got to find out.
Okay.
Steep learning curve ahead.
Watch this space then.
Be the same, it'll be exactly the same basis of appeal, lack of due process of law. I've just-
Doom, 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 da 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 da.
What do you know?